From the Library of Congress in Washington, D.C.
Good afternoon, everyone. My name is David Mao, and I have the privilege of welcoming you to the Library of Congress. Today, we're very, very honored to have with us Professor Ruth Karras from the University of Minnesota to lead us in a program, Law and the Lives of Medieval Women Beyond Magna Carta. As many of you know, this program is the fourth in a lecture series that the Library of Congress and the Law Library of Congress in particular has sponsored to explore how Magna Carta has had an impact on both historic and contemporary topics. This series was co-sponsored by the Standing Committee on the Law Library of Congress of the American Bar Association. I want to recognize Liz Medaglia, the current chair of the committee. Thank you, Liz, for making it possible for the ABA Standing Committee to be a co-sponsor of our lecture series. As many of you also know, the lecture series corresponds to the Library of Congress exhibition currently across the street in the Thomas Jefferson Building, Magna Carta, Muse and Mentor. That exhibition opened last November, and it runs to this coming Monday. So for those of you who may not yet have had a chance to see the wonderful Lincoln Cathedral 1215 King John Magna Carta, I hope that perhaps after the lecture this afternoon, you'll be able to walk across the street and take a look at the Lincoln Cathedral Magna Carta, as well as the many other fine items from the Library of Congress collection that are in that exhibition. Professor Karras is professor and chair of the history department at the University of Minnesota, and she'll lead us today in a discussion on the way law affected women at different levels of society in medieval England, excuse me. She's a distinguished historian who teaches and writes on various aspects of medieval social, cultural, historical, medieval social and cultural history, gender, and sexuality. As you see from your program, she has written quite a bit. Her most recent work, On Marriages, Women, Men, and Sexual Unions in Medieval Europe, is a winner of the Joan Kelly Memorial Prize in Women's History from the American Historical Association. Professor Karras received her undergraduate degree with distinction in history from Yale. She has a Master of Philosophy in European Archaeology from Oxford University and a Master of Philosophy in History from Yale University, as well as a doctorate in history from Yale. So it's with great pleasure that I hope you will join me in welcoming Dr. Karras to come and lecture to us today. Thank you very much.
Thank you very much for the kind introduction and for the invitation to be here and to talk about women's history in relation to Magna Carta. Law obviously has a very great bearing on the way women were able to live their lives in the Middle Ages. Here we see a medieval law court noticeable for the absence of women. But in the Middle Ages, it wasn't necessarily the letter of the law and what the court did that was determinative of women's behavior. Across the Central and later Middle Ages in England and elsewhere in Europe, women were able to do much more than you might think their legal disabilities would let them do. Let me be clear, I am not suggesting that women enjoyed equality to men in the Middle Ages, even a rough and ready practical equality. Women of any social status had major legal, economic, and social obstacles compared to their brothers. However, as we look at how individual women interacted with the law in the areas of land ownership, marital choice, and commercial activity, we'll see that they were able to create some freedom for themselves within the constraints of the law as they knew it. And the questions of what women's status and legal rights were more complicated than they might seem. Since the occasion for this talk is Magna Carta, I'll begin with the story of one woman who lived shortly before that time, Matilda or Maud of Gloucester, Countess of Chester. And Susan Johns has written particularly interestingly about this character. So Matilda was born into a rich and important family, probably born somewhat before 1135. Her father, Robert of Gloucester, who is, okay, here's Matilda. Her father, Robert of Gloucester, was an illegitimate son of Henry I. Henry I had only one legitimate son who lived past childhood. This is William the Atheling, who was killed in a shipwreck at age 17, leaving him without male heirs. His legitimate daughter, Matilda, this is a particularly difficult period because everybody has the same name. It's you know, Matilda if you're a woman, and Henry if you're a man, more or less. So his daughter Matilda was wife first of the German emperor, later of Geoffrey of Anjou, fought a civil war for many years to take the kingdom from her cousin Stephen, and she was in her activity in the Civil War. She was greatly aided by her half-brother Robert Fitzroy. Robert Fitzroy was one of 24 children whom Henry fathered out of wedlock. He was born before Henry's marriage, so he was less likely to arouse the Queen's jealousy than were the bastards who were born after Henry's marriage. So he was given a great deal of favor, and in 1119 he married Mabel Fitzhamon, who was the daughter of Robert Fitzhamon, Lord of Gloucester. And she was an heiress. That is, her father had no male heirs, so she got the land. And so Henry made Robert the first Earl of Gloucester in 1121 or 1122. Matilda was one of seven children of this marriage who grew to adulthood. There was at least one child who died young, and perhaps more. So she was not the heiress to the Gloucester lands because she had brothers, but her husband, Ranulph II of Chester, was one of the greatest magnates of Anglo-Norman England, and he was a supporter of the Empress Matilda in the Civil War against Stephen until 1145, when he saw which way the wind was blowing and switched to the other side. Matilda was, so this Matilda, our Matilda, was a major supporter of her husband in his military efforts. At one point, when she was staying in Lincoln Castle, she provided an excuse for her husband to enter the castle, which he then captured after she helped him sneak in. Her husband, Ranulph, died of poisoning in 1153. One chronicle accuses her of collaborating in his poisoning, but probably not. She lived as a widow then until 1189. Her son was only 6 years old when Ranulph died, and she retained custody of him and of his land, which is unusual. For a widow to have custody, physical custody of her children was very common. For her to also have custody of her children's land was unusual. She was able to issue charters, legal acts documenting a transfer of land. This is not one of her charters, but it's one from the period. So she issued charters of her own, as well as in the name of her son, for 9 years until he came of age. To give Matilda some context, I want to go back to the title of the talk, Law in the Lives of Medieval Women, and I want to talk about these 4 different ideas in the title. First, law. Okay, that's the wrong slide here. There. Well, that slide will be relevant, but later. So, medieval law. Even leaving aside criminal law, which I'm not going to talk about, people in the Middle Ages were subject to several different bodies of law, as is true today. Right? Cities had their own laws. Different regions within the same monarchy might also have their own law. For example, England and Wales, Flanders and Bavaria within the Holy Roman Empire, completely different bodies of law. Serfs were subject to the courts of their lord. Kingdoms had statute law, but customary law was also important. Groups who were considered to be foreigners within a particular jurisdiction, Italian merchants in England, Jews, wherever they were found across Europe, had their own bodies of law and were allowed to decide disputes among themselves according to it. But so the idea that you're subject to laws at several different levels of jurisdiction, I mean, this is the case today also, but medieval Europe had a whole separate legal system also of church courts. from the level of the rural archdeaconry on up to bishops' courts and appeals to the papacy. Canon law still exists in several churches, but today you can opt out of it by choosing not to belong to that church. In the Middle Ages, you couldn't opt out of it. You're subject to it whether you wanted to or not. And the church courts enforced canon law, which was a set of rules composed of statements by the church fathers and rulings by various popes. 1215 is not only the 800th, is not only Magna Carta, we're also celebrating the 800th anniversary this year of the Fourth Lateran Council, which is perhaps the most important church council before the 16th century. And one of the things that the Fourth Lateran Council did was to put together a list of canons on theological and disciplinary topics that created standard church law for hundreds of years. But the most important milestone in canon law actually came not in 1215, but somewhat before that, at an unknown date around 1140, when the law professor Gratian, or someone else using that name, compiled a work called the Decretum, or Concordance of Discordant Canons, which collected the authorities on each point and decided among them. This was a textbook. It was not a legislative act, but it became the basis for canon law as it developed throughout the Middle Ages. Okay, why is this important here? Because canon law governed marriage. And marriage is critical to medieval women especially. Marriage was not a matter for the state at this time. Marriage was important to men too, but it didn't change men's status drastically. Men didn't gain new rights because they were married or lose rights because they were married. Indeed, Janet Loengard suggests that in terms of property rights, the real distinction in medieval England was not between men and women, but between men and single women on the one hand and married women on the other. And married women are the ones who didn't have property rights. So while the legal rights of a woman in relation to property were determined in part by the secular power under whose jurisdiction the property was located, her personal rights were deeply affected by whether or not she was married, and that was determined by canon law. Now, this is women's status in relation to property, but it's important to recognize how much of medieval law was about property. Even litigation that took place in a church court over whether or not a marriage was valid often had to do with property, because if someone wasn't born of a valid marriage, he or she couldn't inherit their father's property. Even criminal law was largely about theft of property, which it treated very harshly. And this is one of the reasons why when we talk about the history of law, we're often talking mainly about the aristocracy. They're the ones who had the property. This is true both of law as an object of study in itself and law as evidence for social history, which brings me to the second term of the title, which is lives. It's arguable that a lot of law was in fact not about people's lives. It was about what happened after their deaths in terms of who got their property. But the point I want to make about lives is very little of the evidence that survives to us as historians is about everyday life. When it comes to writing the history of women's lives, legal sources provide us with three kinds of information, none of which tells us what the people who lived through these situations thought of it. The first is prescriptive material, enactments, such as Magna Carta or papal decretals. These tell us what lawmakers wanted the law to be, but not how people actually behaved, in part because people flouted the law, but also because law is not always intended to be entirely followed. Sometimes it was to be the first step in a negotiation. The second type of source is the learned law, that is, treatises written for scholars or students. These works are in part descriptive as well as prescriptive. They describe how the law is rather than making new law, but works like this often contain a good deal of wishful thinking. The 12th and 13th centuries were the great era of systematization, including in law. Scholars wanted to make everything make sense, so they tried to reconcile things that sometimes were not reconcilable and may have distorted the situation before them in so doing. The third major source of evidence about people's lives and the effect of law on them is what scholars call documents of practice. And these are materials that are created in the course of legal process, such as the records of court business, depositions, notarial registers, wills, and so forth. This is the lateral psalter, and these scenes are often taken to be illustrations of a legal dispute. Nobody, as far as I know, has any good thoughts about exactly what this legal dispute is about. And I'm not going to try and do that here. This is just sort of an illustration, but to an indication of how little we know really about what went on in day-to-day terms in legal relations on a grassroots level. Documents of practice get us closer to the actual lives of medieval people than anything else, not only than any other legal sources, but closer than anything else, period. But there are some problems with using these fascinating stories as sources. Stories may not be a fair representation of what went on. People may have lied to the court, although maybe not as much as we might expect. People took swearing on the gospel very seriously. But the larger problem is not the question of truth-telling, it's a question of an unrepresentative sample. Notarial registers may give us a fairly random sample of business transactions for a given time and place, but they weren't used throughout Europe, not in England, for example. And they only tell us about people who controlled enough wealth to enter into transactions and be able to pay a notary to record them. Documents like court records in some cases give us more information, but they still tell us only about disputes that came into court. That is, when everything went the way it was supposed to, we have no record of it. So this makes society appear a good deal more disputatious than it may actually have been. And court records, again, are biased towards the higher levels of society. To sue someone, you generally had to hire a lawyer, or even in lower courts, where not everyone's represented by a lawyer, you had to pay a fee just to get into court. Legal records also see things through a particular lens. If you have a grievance, you have to frame it in terms that the legal system will deal with. The stories that people tell in court are shaped to conform with legal requirements. So even if they're not lying, they're leaving out details that are irrelevant to the case and telling their story in a way that fits an accepted legal fact pattern. There's also a good deal of negotiation and collusion that went on behind the scenes and is invisible to us. We can get some information out of court records. I did a study over 2,400 pages of records from an archdeacon's court in Paris over a period of 20 years in the late 15th century, a court that was much used by the common people. This is just an example of what these court records look like. This is not one of these beautiful illustrated medieval manuscripts with the nice calligraphy. These are things that are scrawled on the spot and rather difficult to read. But if you read enough of them and put them in a database, you can learn some things about how the common people are behaving, and I'll talk about that in a little bit. The third term in the title of this lecture is medieval. The Middle Ages are generally taken to run from around 500 to 1500. I'm going to be dealing here only with the late 12th century on, but I want to make 2 points about the Middle Ages as a concept. First, this period is crucial for the development of Western law. Much of Europe and former European colonies bases their law on Roman law, but it was in the Middle Ages that the Roman law was adapted and developed into the medieval civil law and also the canon law, together called the jus commune or droit commun, common law, but not to be confused with English common law, which is something entirely different. So both the English common law and the civil law or droit commun come down to us from the Middle Ages, not from the Roman period. So this period is central in law as we get it. The second point is that because these two systems, which shared a lot of features and assumptions, are so dominant today, it's really only Russia, China, and Japan as major areas of the world that are not under a legal system, either the Roman civil law or the English common law. Anyway, because these systems are so dominant today, there are a lot of things in medieval law that don't look very surprising to us. It's like, well, of course, that's the way the law does things, because we're used to it. But if you really want to understand why things were the way they were, you have to be like the proverbial anthropologist from Mars, coming to the material without contemporary assumptions. Finally, the term women. Again, we know what women means. I'm not going to go all postmodern on you and talk about the fluidity of gender identity. Medieval people had in mind a pretty clear binary between men and women. But that doesn't mean that all women were the same. Women were not one class of people any more than men were one class of people. The lives of women in the aristocracy were in many ways more like the lives of men in the aristocracy than like the women of the peasantry. Women's legal status also varied across different regions, but more importantly, as I said, women's status under the law varied significantly depending on their marital status. Often you'll see, if you read history, you'll see historians writing about women who bought and sold land, women who donated property to monasteries, carried on other economic activity, and this demonstrates that women could do X, Y, or Z. In the vast majority of the examples that you'll see historians using, they'll say this is about women. It's actually about widows. So one subset of women. And the status of widows is in many ways more interesting than that of wives or unmarried women. And as far as unmarried women is concerned, the law was most often interested in them in their capacity as daughters. Magna Carta does not say anything about women as women. This is the National Archives copy of the Magna Carta. It is from later on in the 13th century. The copy that is now on display in the Library of Congress is one of the four copies that were made immediately after the signing in 1215. This Magna Carta didn't change things for most English men. It's largely about aristocratic property rights, and it's only centuries later that it came to be read as a milestone in guaranteeing the liberty of the subject and later liberty of the citizen. But even when it comes to property rights, it's not clear that women were included in the free tenants whose rights the Charter protects. So Magna Carta talks about widows, and so is relevant to the position of a woman like Matilda of Gloucester, who lived in the half-century preceding it. Clauses 7 and 8 of Magna Carta are relevant to widows. So after her husband's death, a woman shall have her marriage portion and her inheritance at once, and without any hindrance, nor shall she pay anything for her dower, her marriage portion, or her inheritance, which she and her husband held on the day of her husband's death. Her marriage portion was property that came from her birth family, as was her inheritance. Her inheritance is not what she got from her husband. Unlike today, a woman could not be her husband's heir. But the property that she got from her birth family, her husband had complete control over during his lifetime. She didn't get to decide what happened to this property, even though she was technically the owner of it. This clause suggests that the king had been putting obstacles in the way of women getting their property back after their husband's death, or that he charged them for getting their property back. As far as dower being assigned to them, a widow was entitled to a third of her husband's property for her lifetime only. It didn't become hers to do as she pleased or to bequeath to whom she wished, but she got the income from it during her lifetime. Dower could be nominated, that is, when a couple married, the woman could be granted specific properties as her dower, and if it wasn't nominated, by the 13th century, it was most common for widows to get a standard third, and the heir would decide which estates she got. So why is this provision in Magna Carta? The charter was conceded by the king to the barons. Why were the barons interested in the rights of widows? Well, the barons who demanded Magna Carta from the king were tenants-in-chief. That is, they held land from the king as their lord. Any fines that the king was collecting for entering into inherited land, he was levying as lord rather than head of state. And the provision of Magna Carta was intended to prevent the king, as lord, from withholding the widow's family inheritance or charging her for receiving her dower. And the lords who were demanding this from the king didn't want their mothers, their wives when widowed, to be subject to these fines to their lord, the king. A similar background appears in Clause 8. No widow shall be compelled to marry so long as she wishes to live without a husband, provided that she gives security that she will not marry without our, that is, the king's consent, if she holds of us, or without the consent of the lord of whom she holds, if she holds of another. So the original idea behind the fief was that it was held in return for military service. But because women couldn't do military service, the Lord had the right to approve the man that she would marry, who would actually do the service that was due from the fief, or even choose the husband for them. This was true of the marriage of heirs and heiresses, both boys and girls who were underage at the time their father died. The Lord had the right to approve the marriage of any heir or heiress, and eventually that right became a saleable property. The Lord would sell the marriage of an heir, the right to marry that person. That doesn't mean that the purchaser would necessarily marry the widow or heir or heiress himself. He could choose the spouse. It might be one of his children. There exists a document from 1185 during the reign of Henry II called the Rotuli de Dominibus et Pueris et Puellis de Donatio Regis, or the role of ladies and boys and girls in the gift of the king, and it listed these people by county. For example, the wife of Everard de Ros, who was the daughter of William Trissabut, is in the gift of the king and 34 years old, and she has 2 sons. The older is 13, and her land is in the custody of Ranulph de Glanville. The land of the said lady in Strausston, which she has in dower, is worth £15 a year. The daughters of Matthew de Neville are in the gift of the king, with the land they have in Denton, which is worth 8 marks a year. If a plow and 100 sheep were added, this land would be worth £8 a year. The ages of the said girls are unknown to the jurors since they are overseas. So these rolls were for the king's internal record keeping. This is not the medieval equivalent of a dating site. This is not something that people could look at to find out who's available for marriage. This is for the king to figure out which marriages he can give away or sell. But the king could use marriages with the people on this list as a way of exchanging an income stream that he got from their property, as long as they were not married, for ready cash when he sold the right to marry them. And the barons didn't want their daughters or their wives to be forced into marriage with the king's favorites, or to be forced to pay to be released from an unwanted marriage. And that's why they were insisting on this clause in Magna Carta. Now, Matilda of Gloucester is one of the women who appears in this roll. Her annual income from one of her dower lands listed in the roll is £22 a year, but she clearly held other lands as well. By 1185, when the roll says that she was 50, but she was likely at least a few years older based on on when her children were born. So by this time, she was near the end of her life, and she had been a widow for 30 years. So she had not been forced to remarry. We don't know whether the king had tried to push her to remarry. She certainly would have been a prize as a marriage partner, not just because of her land, but also because she was the cousin of Henry II, who came to the throne in 1154 on the death of King Stephen. If she had a personal relationship with Henry, who is her nephew, she could have persuaded him not to push her to, no, he's her first cousin, sorry. She could have persuaded him not to push her to marry, or she could have paid a fine for her free widowhood, that is, her right to remain a widow. Her mother-in-law, at the time of her widowhood, had paid 500 marks, a huge amount, not to be made to marry for 5 years. Matilda, in any case, was an exceptional woman who was able to escape being used as a token of exchange between powerful men, although during her first marriage she was certainly serving as such a token. During her husband's lifetime, she had already exercised rights over property, even though technically women couldn't do that. She'd witnessed a number of charters of her husband's, a sign that he wanted her involved in his land transactions. And she'd also granted her own charters, despite the fact that a woman, in theory, had no control over her land. Her husband was certainly approved of her doing so. There are charters granted by her and granted by him on the same day with the same witness list. And there are also charters in which he confirms donations she had made. So, for a woman probably would have had more trouble doing this against the will of her husband. But nevertheless, he is not disposing of her land, even though the law says that he should. She is disposing of her land. There's a question as to whether these donations were valid if they're made by a woman alone, but Matilda was a woman of enough influence within her marriage that she could make these donations on her own. It was normal for a widow to have physical custody of her underage children, as I said, but that doesn't mean they had custody of the child's property. In the case of Hugh of Chester, his lands were supposed to be administered by the crown, his lord, but Matilda parlayed her custody of the person into custody of the property. She appears as co-grantor on the charters that her son issued during his minority, and after he came of age, she had to get his permission to grant land. For example, she was a major patron of Repton Priory, and there was land that she held in maritagium, that is, a marriage gift from her husband that was hers for life, but it would revert to his heir, that is their son, after her death, and therefore the heir had to give permission for her to alienate it. So she, technically, again, was not able to dispose of land on her own, but the heir is her son. Of course, the son's going to do what his mother tells him to do. Now, if the heir had been a stepson, she might have had more trouble. So during her husband's life, Matilda's legal existence was closely tied to him, but it wasn't wiped out. Contemporary law textbooks say that married women could not grant land, but they clearly could. If the heir was their son, they would normally be involved with him in a family property strategy. And this is precisely why the barons in Magna Carta wanted to prevent widows being forced to remarry. They wanted their mothers to work with them. They didn't want their mothers to turn the dower land over to new husbands. At the time Matilda's marriage was formed, however, Matilda would have had less freedom of action than she had later as a wife or a widow. If her age as given in the roll is correct, she was married at 7 and had her first child at 12. It's likely that this roll is wrong, that she would have been married no younger than 12, which would have put her first child at age 17. It's probably not news to you that medieval marriages were arranged, especially at the aristocratic level. But it's important to keep in mind that in the 12th century, the church came to put a very high value on consent. The consent of the parties to the marriage, not of their families. Now, consent is not the same thing as choice. Or rather, we might say there are two aspects to choice in marriage: whether you get married and to whom. The choice whether to marry could mean taking a vow of celibacy. And the church, for the most part, supported women who took such vows, even if their family didn't want them to. I'm not going to discuss that today. The second part of the choice, whom to marry, could have two parts: consenting to a choice made by your parents or exchanging consent with a person of your own choosing. There was considerable discussion over the course of the 12th century among theologians and canon lawyers as to whether consent alone was enough to make a marriage in the absence of the consent of the family or a written contract or a church blessing or an officiant conducting a marriage ceremony or consummation. And the position that won out was that consent itself was sufficient. You didn't need any of these other things. If two people exchanged consent, whether or not a priest was present, whether or not their parents agreed, whether or not they consummated the marriage, that marriage was valid. But that, in practice, however, it was often consent to a choice made by someone else. It doesn't mean that at the higher reaches of society, people were normally choosing their own partners. However, as we see from a very interesting case a few hundred years later, a marriage formed by the consent of the parties could not be dissolved. Marjorie Paston was born around 1450 to a well-off family of gentry in Norfolk, and we know a great deal more about this family than we know about most medieval people, because in the 16th century there was a big lawsuit, as a result of which all the collected letters of this family over a several hundred-year period were entered into evidence and survived. So the Paston letters give us many touching stories about the negotiation of marriage, which involved, first, the negotiation of an appropriate match by parents or other relatives, and then second, the wooing of the woman by the man, because she, even if the marriage was already arranged, she had to be brought to agree. And so we see women refusing to marry their parents' choice. We see marital arrangements falling apart because of financial factors. We see love letters between a couple whose financial arrangements have not yet been made, including the first known Valentine message from Marjorie's future sister-in-law to her brother John. And this letter begins, worshipful and my right well-beloved Valentine. And they are not married yet. This is sort of a love letter after the marriage has already been arranged. We see people in arranged marriages, like this couple eventually, living very happily together. We also see this marriage made by the consent of the parties alone. In 1469, so at the age of about 19, we know from a letter from Marjorie's mother to her brother, Marjorie ran off and married the family's bailiff, Richard Cull, without her parents' permission. Now, a bailiff was respectable. It wasn't a manual laborer, but was not the same social standing as the family. He was a son of a shopkeeper, even though he had been recommended to the family by the Duke of Norfolk. Cull was a trusted retainer who handled a lot of sensitive business for the Pastons, but he wasn't a gentleman. The family forced the couple to separate, and during Cull's banishment to London and Marjorie's near imprisonment in the family home, Cull wrote to her, "We that ought a very right to be most together are most asunder. Meseemeth it is 1,000 years ago since that I spoke with you." Her parents, who knew the local bishop well, complained to him, and he examined Marjorie and Richard separately and found that they were in agreement about the form of words they had exchanged, and it was a valid form for marriage. And the bishop urged her to be guided by her family. And then, in the words of her mother's letter, and she repeated what she had said, and said if those words made it not sure, she said boldly that she would make that surer before she went thence, for she said that she thought in her conscience she was bound, whatever the words were. So in other words, if we didn't say the right words to make us validly married, then tell me what those words are, and I'll say them right now. The bishop delayed ruling in the case in the hopes of being able to fulfill the family's wishes and invalidate the union, but he didn't find any grounds to do so. He declared that the couple were married. We don't know what kind of relationship she had with her family after this. Cull lost his job and worked for a while for a monastic house in Norfolk, but 3 years later, the letters show he was back in the Paston service. They decided they couldn't do without him. Marjorie doesn't appear in the letters. As far as we know, her family cut her off. But in 1482, when her mother died, her mother left 20 pounds to the oldest of Marjorie's 3 sons. So they were at least recognizing the marriage and their grandchildren. We don't know when Marjorie died. We do know that Cull survived her and had 2 sons with a second wife. By the 15th century, then, the church was willing to actively enforce what we know was legal theory in the 12th century. This is not what the church intended when it set up the principle of consent. Rather, the intention was to take authority away from families and give it not to individual marriage partners, but in the hands of the church. But if the church wanted to control people's unions, it had to declare legitimate the ones that people made by their own choice. Part of the reason the Pastons were so upset about Marjorie's marriage was that it was socially inappropriate. Another part was the lack of property exchanges, which were normal and expected in a marriage, even though the church did not require them. It's not entirely clear that in the 12th or 13th century, the church would have protected the validity of Marjorie and Richard's self-made marriage, as it did in the 15th. But by the later Middle Ages, we have court records that reach down to a lower level of society, and we see people, especially servants and manual laborers, marrying relatively late. Men in their mid to late 20s, women in their early 20s. At this point, neither the men nor the women are living in their parents' households anymore. Jeremy Goldberg has demonstrated this to be the case for York in England and proposed a distinctive English marriage pattern based on this. I've shown that the pattern for Paris in the same period was not much different, so I don't think it's distinctively English. I think it's distinctively lower end of society, people marrying later than they are as aristocrats. And for people who property is not a major issue, marital choice was much freer for women as well as for men. And in the Paris court records, we see couples exchanging marriage vows in places like stables, which is where the male servants slept. They show up later in court because one member of the couple is denying the vows and saying, no, we weren't really married. But other servants who had witnessed them then came and testified. And we even in these court records, we see not only servants and workers, but daughters of the bourgeoisie who make secret betrothals and attempt later to get their parents' consent and settlement. And it comes into court because the daughter enters into a betrothal and then the father refuses to give her a marriage portion because it wasn't his choice. And then the betrothed doesn't want to marry her anymore, or she makes a betrothal and then her parents arrange a different marriage for her, and she says, well, and then the first fiance comes forward and says, no, she can't marry this guy because she was previously betrothed to me. So even at levels of society where there was property, we see people attempting to make their own marital choices and the church upholding these choices. Back to Magna Carta, we see that a widow has to give security that she will not marry without the consent of her lord. But the charter does not try to claim that if she did marry without the consent of her lord, it would invalidate her marriage. It wouldn't. What would happen is that she would forfeit her security, and she'd forfeit her dower land. In leaving open the possibility that in the absence of this clause, a widow would be able to choose her own husband, Magna Carta implies the influence of canon law already at this point. Okay, there is a Italian lawyer, Vicarius, who was living in England from 1148 to 1198, teaching Roman law there and writing a tract on marriage, and does write about consent doctrine. It's not clear how far his law was known, but it's clear from his work while teaching law in England that the consent doctrine of espoused by the church was known. The clause about the widow giving surety would also seem to suggest that it was known and practiced in England. The other question, however, is if consent was sufficient for marriage, was it also necessary? That is, could marriage be made without the express consent of the parties? And it's quite clear that the theoretical answer to this under canon law was no. By the 12th century, consent by the parties is part of the formal marriage ceremony. The church was willing on a few documented occasions to protect the party who did not consent, even if it was a young girl being forced by her parents. We can only imagine how difficult it must have been for a young girl. Girls could marry at 12, and among the aristocracy, some were married off earlier. It must have been really difficult for a girl to go against her parents' wishes when they're telling her you have to marry this person. And the church had to figure out how much coercion was permissible. Force and fear was an impediment to marriage. That is, it could lead to an annulment. By the 15th century, the church courts were ruling that for a father to threaten to withdraw financial support from his daughter was a sufficient threat to constitute force or fear. That is, if a girl consents to marriage under a threat from her father to withdraw financial support, that marriage is invalid. What about the 13th century? What sort of compulsion is Magna Carta envisioning when it says that no widow should be compelled to remarry? There is a possibility that it meant physical compulsion. Much of medieval rulership comes down ultimately to a threat of physical violence. But I don't think we should imagine here a widow being dragged to the altar by the king's men-at-arms. Magna Carta, as I said, is largely about property. It does provide, notably, that no free man shall be taken or imprisoned without the lawful judgment of his peers. But people who quote this as, the central tenet of Magna Carta that's become important in U.S. Bill of Rights and so on, often omit the next phrase, is taken or imprisoned or disseized, that is, have his land taken from him. And that was, and the rest of that clause is concerned then with property rights rather than with liberties having to do with the physical body. The compulsion here that Magna Carta wants not to be brought to bear upon widows is the loss of their dower lands. And if we look at the practice in the reign of King John, who granted Magna Carta, and before, the possibility of the seizure of the dower lands was in fact a pretty veiled threat, if it was a threat at all. It wasn't used really to compel widows to marry the person the king chose for them. What it was used to compel was to compel them to buy their way out. Widows reached an agreement that is called making fine, that is, making an end, and that's the origin of our term fine. They made fine with their lord not to have to remarry, and there's lots and lots of records of this in the king's financial registers. The king was perennially short of cash, and it was often more lucrative for him, rather than selling the widow's marriage, he could sell her right not to marry, that is her free widowhood, to her herself. And he could make more money from this because he could sell it over and over again. As I said, with Matilda of Gloucester's mother-in-law, he sold her her free widowhood for 5 years. At the end of 5 years, he could get her to pay again, to not marry again for the next 5 years. Magna Carta also contains other passages referring to widows. If a man dies in debt, his widow gets his dower, a third of the property, before subtracting the debts. But let's remember, there is nothing in Magna Carta about married women, even though most women in medieval England were married. Theoretically, married women had no legal existence. They maintained their ownership of things they brought into the marriage, but they were considered covered by their husband, couvert de baron, and therefore he had complete control over their goods, lands, and contracts. They were in many ways like minors today who can't be held to contracts and who they can have property that they've been given or inherited held in trust for them. In fact, in many jurisdictions today in the United States, the earnings of a child still belong to the parent. Although California, for example, has the Jackie Coogan Law enacted in 1939 after Jackie Coogan's parents spent everything that he earned as a child actor. And so California now has a law that requires some of a child's earnings to be kept in trust. Many states don't. In Minnesota, for example, all the earnings of a child technically belong to a parent. Now, this is a big difference between theory and practice. I mean, how many of you, when you were under 18, had a job and your parents let you keep the money, and you probably didn't even know that that money theoretically belonged to your parents? But same thing in the Middle Ages, that theoretically a woman's money is under the control of her husband, but it wasn't necessarily practiced that way. So in theory, a woman whose husband had sold the land or spent the wealth that she brought into the marriage could sue his heir after his death, and the heir had to make good on that. But during his lifetime, she could do nothing because she had no standing, and yet the law of coverture was really systematized not during the Middle Ages. It was systematized during the 18th century by Sir William Blackstone, who wrote a lengthy commentary on the laws of England, and it was he who enunciated the doctrine of unity of person. That is, by marriage, the husband and wife are one person in law. That is, the very being or legal existence of the woman is suspended during the marriage, or at least is incorporated and consolidated into that of the husband. Again, 18th century, and he meant it as a description of what had been the law since the Middle Ages, but then subsequent historians have tended to read it backwards and to say that this was medieval law. And it was theoretically medieval law, but it wasn't practice. The great legal historian F.W. Maitland wrote in his History of English Law that coverture was not a consistent principle in the Middle Ages, and that what was really going on was more like guardianship, because a wife never lost ownership of her property, nor did a husband gain it. The rest of Western Europe, married women were under the guardianship or mundium or tutelle of their husbands. But in England, it was only married women who were under such guardianship. In Roman law jurisdictions, unmarried women were under the guardianship of their father or brother. All women were theoretically under some kind of guardianship. In England, single women past the age of majority, as well as widows, could control their own property, subject to the consent of their lord where applicable. The other difference between England and the continent is that England did not have community property. A married couple might have to undertake some legal acts together, as when the husband conducts litigation concerning a wife's property and she appears in court with him, but the property involved was either hers or his. In continental northwestern Europe, however, property acquired during the marriage was community property, with each partner having a right to a portion of it when the marriage came to an end by the death of one of them. Scholars, notably the legal historian Charles Donahue Jr., have discussed whether this pattern relates to a greater perceived individualism in English society, either as cause or effect. But although England didn't have community property, neither did it have total and consistent coverture in practice. Married women appear undertaking legal acts in court records all the time. We have the charters of women like Matilda of Gloucester. In villages and towns, women are fined for brewing or baking against the assize, that is, they haven't conformed to the rules that brewers and bakers had to follow. They, not their husbands, are fined. In royal courts, they appear alongside their husbands in matters involving debts they'd contracted before their marriage. Perhaps 20% of all cases involving debt are debts that have been contracted by women, and women appear in court responding. In cities, women traded as femmes sole, which gave them the legal status of a single woman, even though they were married. This enabled them to obtain credit to buy and sell independently, but more importantly, perhaps, gave their husbands a way to repudiate debts for which they otherwise would have been responsible. An example of a commercially active woman we find in medieval records is Denise Marla, who lived in the town of Bridgewater in Somerset. We don't know when she was born. She died in 1401, and when she died, she left her servant half of a house, a furnace, all her brewing vessels, 3 sacks of malt, a cup, a brass pot, a pan, a goblet with silver, a dish, 2 silver spoons, and other goods. She left a lot of goods to her daughter and to local churches, including 80 pounds of wool. Denise was a commercial brewer, or brewster, as women were called. This is the slide that I had in the wrong place. Women brewing. She had been brewing for more than 20 years, both before and after the death of her husband, Nicholas, who was a butcher. Her work supplemented his while he was alive and supported her after his death. Since her largest pot held 12 gallons, she likely brewed 36 gallons at a time, that is, using the same malt in 3 progressively weaker brews. She would have marketed the ale locally. Brewing as a woman's trade didn't have the prestige that other crafts did. The story of how it became a men's trade, just at the time it became more lucrative, has been told by Judith Bennett. But Denise lived at a time when it was largely the province of women. Now, Denise should not have been able to purchase her brewing equipment, especially if she bought it on credit, because her husband would have had to obtain the credit. She was not trading as femme sole because her husband was summoned to court on her behalf when her brewing was found to be not up to par. But nevertheless, she had room for a good deal of independent action. During the 13th century, there was a rule of implied agency, which held that a woman was allowed to purchase or sell goods for the benefit of her husband. Although by the 15th century, the courts were requiring explicit permission, which Cordelia suggests that this may have been more widespread than women trading as femme sole, women just trading as agent for their husband. The point is that although overall within Europe, when we see reports of women actively engaged in economic activity without the participation of their husbands, they're very likely to be widows. This was far from a universal rule in England or elsewhere. While far from equality, women were also far from non-existent in the economy, so far as we see that economy reflected in the law. But there was still suspicion of women in trades, especially when those trades were connected with alcohol, as we see here. So ownership and control of property was a source of income and support for women, particularly at the higher echelons of society, and particularly widows. But the fact that the legal system was based on property and the defense of property also held women as a group back, although it allowed individual women to gain a good deal of power. Matilda of Gloucester used her widow's third of a huge estate to become a major patron of the church. Magna Carta attempted to make it easier for women to attain a similar position by forbidding the king to charge them to remain single, and yet over subsequent centuries, most women did remarry and come under the control of a husband. Marjorie Paston had the church protect her choice of a husband, even against her parents' attempt to control her marriage, and yet most women, and indeed men, at least at the aristocratic level, did have their marriage arranged by their families. Denise Marla developed a trade during her marriage that allowed her to support herself in her widowhood, but if her husband hadn't wanted her to do so, she would have been unable. The numerous women in my study of medieval Paris, whose names we know only from one fleeting mention in the court record, and whose backstories are just a matter for sheer speculation, were in some cases able to make their somewhat informal marriage vows stick, but in some cases they couldn't and ended up pregnant and alone. We only know about any of these women because of their interaction with the law. And we could say that this is true of just about any secular woman in the Middle Ages. Law is the window through which we see them. Law was not the only factor controlling women's lives. It constrained what they could do, and it very much constrains what we can know about them. But we can see that they could be resourceful and successful in working within those constraints. Thank you. Thank you.
We have some time. We want to take some questions. There's a microphone in the back. If anyone has any questions, we'll bring a mic up.
Yeah.
I'm just curious, at the time of the Magna Carta, what would be the age of majority, and did it differ between boys and girls? And at what age would children be expected to leave the parental home?
Age of majority for medieval people like to do things by sevens. Okay, so age of majority is either 7, 14, or 21, depending on what on the context. So generally 21 for inheritance of property, 14 for boys and 12 for girls for marriage, and 7 for being able to give consent to entry into a monastery. So the other part of your question was what age people were usually married at? No. Okay.
At what age would children be expected to leave the parental home?
Okay, quite young. And this is true at all levels of society. Okay, children could go to be apprenticed at the age of 7, and often were. They would go in England in particular, and this is not true across Europe, because you get foreign visitors commenting how strange it is that in England nobody lives in their parents' household. That you would have even families that weren't that well off, agricultural workers, instead of having their children work on their land, their child would go work for somebody else, and they'd have somebody else's child come and work for them. I guess figuring you can work them harder when they're not your own child. I don't know. So it was not at all unusual for children to be apprenticed or to go work as agricultural laborers in their preteen years. And there was a recognition that they couldn't do adult work. They would be doing things like, they'd feed the chickens. They'd take lunch to the harvesters working out in the fields when it was lunchtime or something like that. I mean, they did it from a pretty young age. Once you get higher up in society, it was very common for, rich people had much larger households than poor people. Poor cousins would send their children to live in the rich cousin's family to be educated. Among the aristocracy, people would so it was very prestigious to have your child grow up in, say, the household of a duke, or especially in the household of a king. I mean, if you could get people, strove to get places for their children in households the way people try to get their kids into colleges today, and for the same reasons, that it allowed your child to create connections and create a future. So children did often, again, not universally, but they often left home at younger ages than children would leave home today.
Did the rights of women in England change after the Norman invasion? Was the arrival of the Normans good news or bad news for women there?
Well, you sound like you may have read something about this. I mean, this is in fact something that scholars strongly disagree on. So Christine Fell, Doris Stenton, Lady Stenton, who was married to Sir Frank Stenton, sort of one of the greatest legal historians of medieval England, and she was had been one of his students, but was also a major scholar in her own right. So she wrote some time ago, and it was more recently revived by Christine Fell, the idea that the Norman conquest was a step backwards, that women in the Anglo-Saxon period had had exercised much more control over property and much more sort of influence over their male relatives and so on. And I'm not 100% convinced. In theory, yes. I mean, legal doctrine, Norman conquest is a big step backward, right? The whole idea that everything's done by the law of fiefs and women can't hold fiefs, and if they do, it's done in parage, that is, if there is no male heir and the land is divided among his daughters rather than going to the oldest daughter, so the fief doesn't, no one daughter gets the big chunk of land, no one son-in-law actually gets a big chunk of land. It's divided up and fragmented. And so in theory, there are significant legal disadvantages for women that didn't exist during the pre-conquest period. I'm not sure there's that much difference in practice, and sort of one of the things that I'm suggesting here is that the people got around the laws against women's landholding. And the reason they got around it was not because they were big believers in women's rights, but because everybody wanted to have a landholding strategy for their own family, and that they wanted to make use of their daughters and sisters and widows and so on in this strategy. They wanted to involve them in it, just as had been the case in the Anglo-Saxon period. So I'm not sure it's as big a step back as somebody like Christine Fell would suggest. But certainly the legal doctrines do change, and not in a way that benefits women. I would also add, in a way that doesn't benefit most men either, in that your typical small free landholder has technically more rights in the Anglo-Saxon period than they do after the Norman conquest also.
Thank you. Could you please join me again in thanking Professor Karras? Thank you very much. We have run out of time. This lecture will be available on our webcast, but I do want to mention two things briefly. One, I did encourage you earlier to come across the street and see our Magna Carta exhibition, but I just want to remind everyone that this is not the last of our Magna Carta lecture series. We have one more lecture scheduled in April, at which time we will have Nicholas Vincent from the University of East Anglia come, and he's a world-renowned scholar on Magna Carta. He will be coming to talk to us about, of course, Magna Carta. And then finally, before you go, if you have a chance, we do welcome your comments, and I have colleagues here who are walking around with iPads. If you could just fill out a quick information and opinion survey on what you thought of the lecture, and maybe suggestions on other programs we might have for you. So thank you very much for coming.
This has been a presentation of the Library of Congress. Visit us at loc.gov.